Alright, buckle up, because this is one of those stories that sounds like a movie script, but it's happening in real time, right in front of our eyes. For years now, we have all been watching the KANU saga like a never-ending courtroom series. Every season comes with fresh drama, endless adjournments, midnight DSS movements, courtroom theatrics, intelligence agency chess games, and that constant feeling that something big was always being hidden behind the curtains. Many people got tired. Some lost hope. Others believed the ending had already been written. But today, this very moment, Monday, February 9, 2026, we may be witnessing a plot twist so wild, so embarrassing for the prosecution, that it could completely flip this case on its head. What we are about to talk about is not rumor. It's not social media noise. It's not wishful thinking. It's a legal grenade dropped by the prosecution themselves. And the irony? They handed it over willingly. Just a few days ago, KANU's legal team quietly filed a fresh notice of appeal. At first glance, it looked like the usual legal paperwork. But buried inside that document is an error so fatal that lawyers across the country are shaking their heads. An error that makes you ask one uncomfortable question: how did this even pass through the Attorney General's office? Let's rewind a bit. Back in November 2025, the Federal High Court, under Justice James Omos, delivered what many believed was the final blow. KANU was sentenced to life imprisonment. For his supporters, it felt like the lights had gone out completely. The man was swiftly moved from the DSS facility and transferred all the way to a correctional center in Sokoto, far from his base, far from the southeast, far from the center of agitation. It was meant to send a message: this chapter is closed. People said, that's it. The government has won. Even some of his strongest supporters went quiet. But power has a funny way of tripping over its own feet when it becomes too confident. Because in their desperation to secure that conviction, the prosecution made a mistake so basic, so shocking, that it now threatens to destroy the entire case from the foundation. According to the appeal documents filed on February 4, 2026, KANU was charged, tried, and convicted under the Terrorism Prevention Amendment Act of 2013. Now pause there. That law does not exist anymore. It was repealed, scrapped, buried, replaced. In 2022, Nigeria enacted a new law, the Terrorism Prevention and Prohibition Act of 2022. That is the law currently in force. That is the law any terrorism-related charge must stand on. But the prosecution didn't use it. They built their entire case on a law that had already been thrown into legal oblivion. In simple terms, they tried a man using a dead law. And in law, that is not a small error. That is catastrophic. You cannot accuse someone under a statute that no longer exists. You cannot invoke the jurisdiction of a court using a repealed act. It's like trying someone today under colonial laws that were abolished decades ago. No matter how serious the allegations are, the foundation collapses. KANU's lead counsel, Aloy Jimoko, saw this error and pounced on it instantly. In the appeal, they argued that once the charge sheet was anchored on a non-existent law, the entire trial became legally void from day one. No jurisdiction. No valid proceedings. No lawful conviction. No lawful life sentence. Null and void. Gone. And this is where you, the viewer, have to pause and ask yourself a very uncomfortable question. Was this sheer incompetence? Or was this internal sabotage? Because this isn't a typo. This isn't a spelling mistake. This is the kind of error every second-year law student is warned about. So how did it survive drafting? How did it pass review? How did it make it into court? How did it escape the judge's attention? How did it lead to a life sentence? Was someone sleeping on duty, or was someone quietly setting up a technical exit? I want you to really think about that, and drop your theory in the comments. But that's not even the end of it. Because the appeal document drops a second bomb. The lawyers argue that even if, just hypothetically, you ignore the dead law problem, the trial court still committed a grave procedural violation. According to them, justice almost denied Nom Daniel his right to allocution. For those who are not familiar with legal traditions, allocution is not a courtesy. It is a right. Before a judge pronounces sentence, especially a sentence as heavy as life imprisonment, the defendant must be given the opportunity to speak. It's that final moment when the judge asks, "Do you have anything to say before I pass sentence?" That moment matters. It's where remorse can be shown. It's where mitigation can be offered. It's where the humanity of the accused is acknowledged. According to the appeal, that moment never happened. The sentence was handed down coldly. No invitation. No final words. No opportunity to speak. And in appellate courts, denial of fair hearing, even on procedure alone, can be enough to overturn a sentence. So now, you have two massive cracks in this case. A conviction based on a repealed law. And a sentence passed without allocution. Either one is dangerous. Together, they are explosive. And suddenly, things that didn't make sense before start to make sense. Just yesterday, Sunday, February 8, 2026, IPOB made a surprise announcement, the total cancellation of the sit-at-home order across the Southeast. The directive reportedly came directly from Nom Daniel himself, from inside his cell in Sokoto. Why now? Why the sudden calm? Why the sudden call for peace? Because a man who believes he is about to lose everything does not call for restraint. But a man who believes he has a winning hand in court does. He needs calm. He needs order. He needs to look like a leader who respects the rule of law. And his lawyers are already framing the narrative, a government that claims to uphold justice, yet prosecutes citizens under laws that no longer exist. The notice of appeal has been served. The file is complete. And here's the brutal truth, the prosecution cannot take it back. Once a charge sheet is filed, it becomes part of the permanent record. You can't shred it. You can't pretend it never happened. You can't quietly swap the law and move on. The Court of Appeal in Abuja is now the stage. No hearing date yet, but the pressure is already intense. The judges will be watching. The world will be watching. Supporters, critics, observers, foreign media, all watching. And the question hanging in the air is simple but deadly. Will a Nigerian appellate court uphold a life sentence founded on a repealed law? Or will it do the unthinkable and quash the conviction? One thing is beyond doubt. Somewhere inside the prosecution's office, someone wishes they could turn back time and tear up that charge sheet. But time doesn't reverse. And the law doesn't forgive this kind of mistake. The clock is ticking. And Judgment Day is coming.